we geared this up as really sort of hot issues that trustees of independent schools should be aware of. As I think all of you know, we represent many of the schools that are online, and know many individuals at all the schools that are participating. There are a lot of issues, and so picking sort of a handful to address is somewhat subjective. But we picked some that we think are, if I was a trustee on one of your schools, and I have been, what would sort of action items. And so when we do go through this, we will highlight some areas where we think action is warranted. So just big overview. I'm going to start with the overview, and Donna and I will go back and forth a little bit. But on the overview, trustees are fiduciaries of schools in their capacity as members of the Board of Trustees. Basically, the law for a million years for fiduciary responsibility of trustees has been that there's three primary responsibilities: a duty of care, duty of loyalty, and duty of obedience. These are really common law terms that have been adjudicated and defined in many ways by court decisions over many years. The duty of care is a requirement that trustees be familiar with the school's finances and activities and participate actively in its governance. So, I tell people all the time when they say to me, should I accept, I've been asked to be on a board of trustees of a not-for-profit or a school, should I do it? And my answer is, only if you're going to spend the time and effort to do it right. Just doing it to have something on your resume is not worthwhile. People in schools need real trustees who are paying attention and reading the material and asking questions and participating. And that's really the legal requirement, to care and to be involved. The duty of loyalty is a little bit easier. It's a requirement that trustees act in the undivided interest of the school and its mission, and not have conflicts of interest. And we'll talk a little bit more about conflicts as we go on. And last, the duty of obedience is a requirement that trustees ensure that the board complies with applicable laws and regulations and its own internal policies. Some schools historically don't pay attention to their bylaws or their governance procedures and documents, and the only time they really look at them is when there's a problem and they're surprised to see what's there. We're big fans of looking at it more often and living by the rules of procedure that the board has effectively adopted for its own activities. And they're all could be different. All bylaws are different. All schools are different, as we know. One of the great things that the independent school world is all the schools have different missions and different ways of operating. But it's important that that be in writing and followed, and people care about it. So as we discuss all the things we're going to discuss today, those are the sort of the core requirements. Last thing I should just note from a legal perspective is in New York, the not-for-profit corporation law basically gives some leeway to trustees and fiduciaries of not-for-profit organizations as far as liability. They want people to volunteer to be on boards. They want people to do this for no money. And so it's not that easy to be held fiduciarily liable as long as you pay attention and follow the three duties that I've just spelled out. With that, I'm going to turn it to Donna to talk about some recent developments in this area.
Hi. So I am going to give you kind of the 5-minute high-level overview of the New York Nonprofit Revitalization Act, which hopefully you've heard of before. We've spoken about it for NYSAIS, and it's been a hot topic for the past year or so. We could spend this entire hour talking about it. We won't. So I'm just going to go through some of the but we would be remiss not to bring it up because it's the biggest change that directly impacts trustees and bylaws and policies for the board. So the not-for-profit law, which Mark was just telling you about, had not been changed for about 40 years. It was just completely static. And finally, the legislature decided that it was time to update it. And those updates impact education education corporations and religious corporations. So your schools are probably formed as one of those two, New York not-for-profit education corporations or religious corporations. So these changes likely affect you and your bylaws and your boards. So the Act both eases certain burdens and imposes some additional burdens on schools and their trustees. On the easing side of the coin, we have finally some recognition of electronic transmissions. So notices, waivers, votes, those types of things can be done electronically now. So primarily they're talking about email, which many schools were doing before, but it was not actually permitted by the nonprofit law, and it now explicitly is. So you'll want to go through and add that as an acceptable means of transmission to your bylaws. It also permits video conferencing, so technology like this right now, Skype, Google Plus type of Hangouts, things where everybody can hear each other and see each other can be used for board meetings, for committee meetings, for meetings like that. And that is also just keeping up with the times. The Act lowers the threshold for certain routine real estate transactions to a majority from 2/3. And it eliminates the types of nonprofits. So your school, whether you knew it or not, was previously classified as a type in A, B, C, or D corporation, and eliminates those types of corporations just to be either charitable or non-charitable. And most of you will be charitable. So that's about it on the easing side. Then the Act, it adds some additional burdens or just some additional obligations, things that the New York State Attorney General has seen as issues for nonprofits generally. One big change is the audit committee requirement. So most nonprofits are required now to designate an audit committee. That committee is required to be made up of independent directors. So first of all, that means they have to be directors. They have to be trustees, the members of the audit committee, and they have to be independent, which means that they're not an employee of the school, they're not a relative of a key employee, they have an accepted compensation in excess of, I believe it's $10,000. They don't have a substantial financial interest in the school. So that's an analysis that you should go through before you designate which trustees are on the audit committee. They have to be independent. If you don't designate an audit committee and your entire board winds up serving the functions of the audit committee, it can only be the independent directors of the board doing that. Relatedly, the Act requires that an independent committee or the independent board review any related party transactions and only approve such transactions if they're fair, reasonable, and in the best interest of the organization. And that's something that should be analyzed and documented at the time that you're doing it. The Act further requires that most nonprofits have a conflicts of interest policy and a whistleblowers policy. The conflicts of interest policy applies to trustees, officers, and key employees of the organization, which for schools are primarily heads of schools, sometimes financial business type of directors, sometimes other employees, but it's a little bit of a facts analysis, but those two are almost always included in that. So some schools have conflicts of interest policies for employees. That's a different type of policy. This is for general employees. This is a very specific policy with definitions that are set out in the Act for when there is a conflict. And you'll want to incorporate that both into your bylaws and into a policy where everybody knows how conflicts are dealt with, who they get brought to, how the board approves them, and follow that procedure. The whistleblower policy is a policy that applies to trustees, officers, employees, all employees, not just key employees, and volunteers. And this directly involves the board. They're supposed to have a committee, generally audit committee, who will review whistleblower claims when they come in. So the AG wants the board to be involved in these types of claims, particularly when they're dealing with financial issues at the school. So the action item that Mark was talking about before, there's a lot for trustees with this Act. You'll want to go through. So this took effect, most of the provisions last July, some this January, but most nonprofits and schools are still coming into compliance with it. So you'll want to, if you haven't already, review your bylaws, update them. There are several spots in bylaws that can be updated based on these changes in the Act. Institute, if you don't already have, and review and revise, if you do, conflicts of interest policies and whistleblower policies to make sure that they are in compliance with the Act. That was a nutshell version.
Nutshell version, but just an editorial comment on the news team is we periodically review bylaws for schools. Going back to my original comments, it's very important to periodically review bylaws and not wait until there's a crisis. This law sort of requires all schools, all not-for-profits, to review their bylaws and update them in many ways, just because the law now gives you sort of flexibility to have meetings and meet in ways that you weren't able to in the past. But it's also, are we being governed the way the bylaws state? And so we just are a boarding school. We've spent a lot of time internally dealing with some bylaw questions, but it's not uncommon. There's no standard bylaws that everybody, a cookie cutter bylaw. Every school operates a little bit differently, and the bylaw should reflect how the school actually wants to operate. I was going to move next to another law that passed not that long ago, which is important, and that we see sometimes that there's non-compliance with. George, were you going to say something?
Well, just thanks for noticing, Mark. I just think there's a timely question. Kennedy asked if the conflict of interest and whistleblower policies need to be renewed annually.
So the conflicts of interest policy should be. You may have a new conflict. There may be new things that pop up that require you to disclose an interest, and then the board can go through and review them. So I would have if you have you should have something where trustees submit and say, here are the things that I have interests in, and then you can review and see if those are conflicts. And I would do that every year. The whistleblower policy won't necessarily change. You'll have a policy and you'll have a compliance officer who people report the possible issues to, that they blow the whistle to. So there's nothing that you necessarily need to do yearly. If you're having people sign off that they received that, which is not a requirement, but if you're doing that, then I would do it yearly, because you're going to have different employees and volunteers, but there's no requirement about that.
And Michael, you asked two interesting questions, and because I may convolute them in asking them, why don't you maybe turn off your mute on your microphone and just ask them directly?
Thanks. So the first question I had was, I have recently been informed that a conflict of interest form needs to be presented to nominees who have not yet been voted in as trustees. Does that sound right? That was my first. I guess that was my first question.
It sounds okay. I don't know if it's required.
Yeah, it makes sense to me, but I don't know.
It's really a screening mechanism to determine whether or not a new board member is going to have conflicts, which is going to be problematic. So I think it may not be a bad process, but the fact of the matter is, board members are allowed to have conflicts of interest. They just need to be disclosed, and they need to be dealt with appropriately. So I think it's just sort of a judgment call when you would ask that, whether it's the committee of trustees or whoever the nominating committee is, in evaluating candidates. And once somebody's in, you say, hey, you've been accepted. Do we have any conflicts we've got to worry about? So there's no requirement that it be the first and not the second.
Okay, great. And then my next question was, does the audit committee have to have an accountant sit on it?
I don't think there's a requirement. They're supposed to be educated. They're supposed to be trustees who can understand the requirements of the audit committee, but they don't have to be professionals in that sense. They can learn. They can educate themselves on those topics. In practice, it may not be a bad thing to have, but
in practice,
it's not a requirement.
In practice, it's a good thing. I mean, and a lot of not-for-profits, finding individuals to serve on audit committee with expertise over the financial issues that they deal with is a hard thing to do sometimes. And it's not an easy it's not easy to self-educate. So individuals with real expertise and background are in demand right now for to serve on audit committees and all, and for profit as well. Particularly for profit, they're getting paid a lot of money to be on audit committees because it's hard to find them. I do think it's a good expertise in the scheme.
The only reason I asked is our auditors had suggested it, but I didn't know if it was required.
Yeah.
It's not required, but that makes sense that they would recommend it.
Thank you.
Okay, so I was going to move quickly to the Prudent Management of Institutional Funds Act. And this is a law that passed a few years ago and had a few important ramifications, which I think independent schools, in our experience, haven't fully embraced. The first is it really deals with all gifts being made to the school, all charitable contributions. And what we have found historically is a lot of schools really didn't track the gifts and the intent of the donors necessarily well. And the law basically goosed up the requirements to do so and to account for it correctly on your financial statements, etc. So with the first sort of action item here is to make sure that the forms being used for anybody donating or making contributions to the school are very clear as to what the intent of the money is. If it's to be unrestricted, restricted, endowment, however it's going to be sort of treated, to try to be as clear and unambiguous as possible and keep records about it. For a actually big college, we had a huge project of trying to go back for each of their schools to determine what the intent of the donors is. It can get really ugly, but it's very important to do. And there's procedures how to clarify donor intent if it's unclear. The other piece of it, which I think is just equally as important, and is the sort of, I'll call the investment side of it, that boards of trustees are responsible for investing school assets appropriately, and is a prudent standard that's now been officially enunciated. And there's instructions through the Act about requiring an investment policy and minutes of meetings and procedures in dealing with investments. The concern of the law, where the law was really passed not that far after the Madoff scandal occurred, and part of the, a bunch of educational institutions got burned in the Madoff scandal. And part of the reason that the law got passed was a concern that in a lot of schools, the investment committee or those responsible for investment are board members or investment professionals, and that they don't really follow appropriate sort of due diligence, fiduciary sort of standards in investing. At a lot of schools, you get some famous investment guy on the board and he'll say, "I'll do you a favor, I'll take your money and put it in my fund," and everybody's excited about that. And that's so it can be a great thing, but that goes right to conflict of interest. Number one, and number two, it really goes to a prudent and diligent investment process. So we think schools really have to, pay more attention to the investment side of the equation, both having written investment guidelines, which the law wants, investment objectives, prohibited and permitted investments, an analysis of what kind of risk you want to take, asset allocation, diversification, procedures for monitoring performance, scope in terms of delegation of investment management functions, investment management's accountability, procedures for selecting and evaluating external agents. You may have a custodial bank and others, and processes for reviewing investment policies and strategies. And it's all to be documented. I'm actually, I would say I'm surprised, because we represent a lot of not-for-profit institutions, pension funds, a lot of institutions, and almost all of them have an investment consultant who they retain. Not only do they delegate the money to investment managers to manage, but they have consultants who help with guidelines and more importantly, help with monitoring performance. So, you know, as some of you may have heard me say in the past, you could be up 25% one year, but that could be really bad because everybody else is up 50%. Or you could be down 25% for the year, and that could be really good because everybody else is down 35%. And the only way you know that is by having somebody come and present sort of independently comparables as to what other not-for-profit institutions or educational institutions are doing generally with their money. And so I've always thought, I'm always surprised that most educational institutions don't go that extra step. I think it's actually a good thing to do. But at a minimum, the board should be adopting and have a written investment policy, and that policy should be reviewed periodically, and the investment committee should be held to making sure they're in compliance with the investment parameters. Last thing I just wanted to mention again quickly is a lot of schools have 403B plans for their employees. There's a lot of legal requirements dealing with compliance with 403B plans. We have a pretty active practice fixing messes with 403B plans because everybody has expected TIA-CREF to sort of just take care of everything. And our experience has been that is not what they do. Not being critical to TIA-CREF, they provide a great service, but they do expect a retirement committee or a committee to be responsible. Somebody's the fiduciary of the 403B plan and have even more fiduciary responsibilities because it's governed generally by ERISA, which is a higher level of fiduciary responsibility, legal fiduciary responsibility. And so we've had many conversations with school personnel over the years about, you know, who's monitoring, who's in charge of your 403B plan, and you know, who's making sure you're in compliance with all the laws and the regulations and the communications and the investment decisions, and investment choices. A big issue that we recommend action plan would be check what's happening with your 403B plan to be in compliance. Me. Okay, next topic we're going to cover, again, relatively quickly, but is student disabilities and accommodations. There's a federal law called the Americans with Disabilities Act, state laws and city laws that deal with disabilities, and everybody's always surprised to hear that those laws apply to schools, not only in the employment area, but with students. And one of the reasons why people are surprised about this is the law applies to public accommodations, and private schools aren't instinctively considered a public accommodation, but by statute they are a public accommodation, even though the public basically doesn't have access to the school, but clearly by definition. And so we deal with the American with Disabilities Act at schools in a lot of ways, not only with compliance on the employee side of the equation, where there are lots of issues at all times, at all employers, including schools, but in the admissions area, in the discipline area, and obviously it comes up in construction and in the sort of physical plant in general. The sort of major area that we deal with is sort of identifying if a student has to have accommodations. And the big sort of story here, and many of you I'm sure are familiar with it, is parents go out and hire a psychologist or a doctor or somebody to evaluate, do a educational evaluation of their child. And if there's a determination that the child is, quote, disabled and needs some sort of disability accommodation, they come to the school and say, I demand the following, accommodations for my child, whether it be extended time testing or there's a hearing impairment, some sort of speaker system, or you can just see the list. The list is sort of as creative as the parent body in New York City is. And so we have spent a lot of time interacting with schools, dealing with when schools have to accommodate and when they don't have to accommodate, and how we think they should structure this area. So I'm going to turn to Donna to go into some more details.
Okay. So first of all, quickly, the ADA defines a disability, and Mark glossed over that because we, at this point in time, almost everything is considered a disability. The ADA defines a disability as a physical or mental impairment that substantially limits one or more of the major life activities of the individual, or a record of such impairment, or being regarded as being thought to have this impairment, even if you actually don't. So there's this definition. In 2008, there were some amendments to that act which did not change that definition of disability, but made it very clear that the courts the legislature, I guess, really wanted courts to interpret that extremely broadly, and said, you know, almost everything is substantially limiting. Almost everything constitutes a major life activity: breathing, sleeping, eating, walking, thinking, talking. So, not 100% of the time, but most of the time, impairments will be considered disabilities, and we move on to the other side of that coin, which is accommodation.
And editorial comment, and when the law first passed, we spent a lot of time defending our clients by saying it's not a disability, and it could, and we got great results, depending upon how you define a great result, but for our clients, in that people with serious diseases were not being held to be disabled because their disease did not substantially impair major life activities. They were still able to come to work and function at home, and so even if somebody had, you know, cancer or cerebral palsy, the courts were saying, okay, you have a disease, but it doesn't substantially impair major life activity. The legislature came back and said, stop it, courts, stop it, lawyers. You know, we're not going there. If you have cancer, you have cerebral palsy, you have, you know, Parkinson's, you have whatever it is, high blood pressure. It's an impairment, and we don't want the litigation to be about, is it a disability? We want the litigation to be about, have you accommodated appropriately?
So a school will generally get a request for an accommodation, you know, some kind of identification that a student has a disability, and then the school is expected to engage in an interactive process with the student and their family. This means that they're supposed to talk, they're supposed to engage, they're supposed to go back and forth with each other to try and figure out what the best, a reasonable accommodation is. Schools don't have to adopt a specific accommodation that's requested by a family if another accommodation is also effective and reasonable. They just have to engage in this interactive process. So I'll talk in a minute about having an accommodation policy, which is, we think, the best way to go about engaging in that process. But first, we're going to talk about when you don't have to accommodate.
All right, so basically, we have three defenses that we argue with respect to this area. One is that the accommodation would be unduly burdensome. So if somebody asks you to, you know, put an elevator into the school because somebody has a mobility issue, and to put an elevator into the school is going to cost, you know, $1 million, the argument would be that is unduly burdensome to the school. We can't afford it. The interesting thing about this defense is it depends on the school. A small, struggling school, you know, can't afford a lower dollar threshold, perhaps, than a bigger, you know, more established school with a big endowment. So it's very subjective. It's sort of school by school, you know, situation by situation. The other one is that it's a fundamental alteration, is that by making that accommodation, it would fundamentally alter sort of what the school's about. And the cases here are sort of, somebody applies to, you know, medical school and says, I have a disability, I can't take chemistry. And the courts say, wait a second, you know, that would fundamentally alter what it is to be a doctor. Or you know, there's a school that, we had a school that basically said, we have a liberal arts program, and an accommodation not to take a language or not to take math would be problematic at our school. It may be a very appropriate accommodation at another school where we have a different curriculum and a different mission, but at our school, it's problematic. And the third sort of big exception is if the individual would constitute a direct threat to the safety of themselves or others. And again, not a broad-based exception. It's very specific, and you can't make stereotypical, decisions. So there's a lot of these are tough. That's a tough exception. Again, somebody who's an epileptic, for example, who has a job standing on a ladder. Your answer may say that would be a direct threat to their safety. You'd be shocked at the court cases saying, "Hey, wait a second, it's you can't really prove that." Yeah, you got to really know a lot about the science and the medicine, and it's not necessarily a direct threat. So those are the ones of those three. The ones that we are most successful with in the school area is fundamental alteration. That with the request for the accommodation would change what the school is about, and we've had a lot of success with that, but there's been very little litigation on it. Okay.
I'm going to ask a quick question. I'm going to ask Andrew if he might ask it directly. Interesting question around admission and school mission and requirement that schools accommodate all handicaps or disabilities.
Yeah, I went through a similar, I guess, process where, just one of our children had a very, very small behavioral issue, needed some, extra, focus and things like that. Some schools were extraordinarily welcoming, and so that's, completely not a problem, not a big deal. We provide that, and some were just like, nope, we absolutely are not going to do that, and are not supportive of people who have any other needs besides the most basic. So it seems like, irregardless of whatever the act, whatever you're talking about in practice, it seems like people just won't admit you. And either some schools seem like they are, these are, independent schools, private schools, they're either supportive or they're not. And you have to make your choice accordingly. So, to me, this seems like great in theory, but, I saw it in practice, and it's like it doesn't exist.
Well, one of the reasons that we raise this is that we see a lot of schools who don't implement these laws correctly. And we've done plenty of admissions programs over the years, and many of the questions are the same question, which is, you mean I have to admit somebody who has a disability? And the answer is, it depends. They still have to be able to achieve the academic, requirements of the school, and they have to be able to behave in accordance with the disciplinary rules of the school. But reasonable accommodations is what the name of the game here is. And so in the admissions process, what we preach is schools aren't allowed to ask.
Yeah, they shouldn't be asking you.
They shouldn't be asking. After the child's admitted, then is when the conversation should take place. Just when we apply for a job, anybody on this call, you don't have to say, I'm pregnant, or I have the following disease, or I have the following emotional problems. It's the same law. And so the medical information is really confidential. There are a lot of schools that ask questions that we find very problematic in the admissions process. What we do sort of coach these schools to say is, if it's a small school with limited resources who don't have the money to do what needs to be, that it would be unduly burdensome in their view. We tell schools to say in the admissions process, while we comply with the law, we're small, we don't have a lot of resources. And there may be other schools that are better, situated to deal with certain issues for applicants. There's some schools that are very specialized. Depends on the issue, though. But you're 100% right. I think we're one of the reasons this is on our list of sort of issues. We see lots of problems in this area with regularity, and your anecdote's not surprising to us at all.
No, there's little litigation in the admissions context, but we would say they shouldn't be asking those questions and could get.
Yeah, the other thing we do say to schools, and so this is a school audience, we'll repeat it. It's so hard to get into an independent school. It's so competitive that, even if somebody is doing something wrong in the admissions side of the equation, we see hardly any litigation because, if 100 kids are applying for 10 spots and you don't get in, it's not it's not an easy case to win that it was because of X versus the other, 90 applicants were also denied. So it's a tough one to win on litigation. So we don't see much litigation.
Okay, so quickly, your action item. We recommend that schools implement an accommodations policy. And this way, if you have a policy, responses to requests for accommodations, so obviously this is not on the admission side, this is once you're actually at school, all responses to requests for accommodations will follow the same procedure, and this minimizes the ability of anybody to say that you responded to one request differently than the other. It eliminates or reduces the risk of discrimination claims. So we recommend having a policy, and the policy should include, at a minimum, a definition of disability, which I would follow the statutory definitions. And as we said, properly documented, many, if not most, impairments will qualify. An accommodations committee, and this will vary depending on who's on the committee, will vary depending on the size of your school and the types of people who you have at the school and resources available to you. But you may have learning specialists, nurses, school counselors, division heads, certain types of teachers. It's up to you to decide who best to review these types of requests. The committee should request documentation to support their analysis and decisions. So you can ask for medical documentation, you can ask for testing where it's appropriate. You need to establish the extent and existence of a disability in order to determine what the proper accommodation is for that disability. So the committee should consider the appropriateness of the accommodation, alternatives, whether there's undue burden, whether there's a fundamental alteration, whether the request might constitute a direct threat to anybody in the community, and go through that analysis, document it, and work with the family to come up with an accommodation that works but is also reasonable for the school.
Yeah, and the basis for this recommendation is a lot of experience, but a lot of parents have beat up school personnel. Say, here's my doctor's word, you must do this. And the answer is, it's not the requested accommodation, it's not the best accommodation, it's a reasonable accommodation. And the whole purpose of having a written policy and a real procedure is to make it a fairer process and not be just beat up by parents in this. And so we highly recommend it. We've seen it really effective.
Quickly, anecdotally, you face both claims from students, potentially, students' families, for failure to accommodate disability discrimination. But we've also seen the Attorney General's office and the Department of Justice, the U.S. Department of Justice, come in, and they have some jurisdiction to review schools and their accommodation process and procedure, and can investigate that, and can also bring a claim if they wanted to on the basis of that investigation for a pattern or practice of discrimination. So something to take seriously.
Okay, so we have limited time, and we will try to cover 3 more topics quickly. The first one's a hot issue dealing with sort of measles and Ebola, issues that we have not dealt with a lot over the years, but a lot recently. I have dealt with a lot recently. So I was asked Donna to quickly summarize.
Okay. I'm going to do that as quickly as possible. So the quick idea is there are requirements from the New York State Public Health Law which apply to your independent schools about immunizations and what immunization students have to have. Important information, the dosing requirements of what those immunization requirements are were revised effective July of this past year. So at a minimum, you definitely want to review your policies and make sure that they're following the appropriate requirements for what students have to have in order to get into school. There's a registry maintained by both the state and the city, which has students' immunization records. Or it should. If it doesn't, you can get them also from other ways, but that's something that's helpful for you to know. A note about preschools and daycares: there are additional regulations for your programs for the small children, including certain requirements for faculty and staff immunizations, which you may not have for the rest of your faculty and staff, so pay attention to that. There's also a recent new requirement in New York City for flu vaccines for children in daycare, preschool, children up to, I believe, up to and including 5. And beginning January 1st, 2016, the New York State Department of Health has said that they'll begin issuing notices of violations to facilities who fail to follow the mandate to make sure that students have those flu shots. So that's the newest thing in that area. But these requirements have been around for a long time. They're just continually updated. And now with the measles, we also have these issues of exemptions and outbreaks. So all students are supposed to have immunizations in order to attend your school. There are 2 exemptions, 2 big exemptions in New York. Those are for medical and for religious. New York does not have a philosophical or personal exemption, which some other states do. I really don't believe in getting vaccines. Not an exemption here, but there is an exemption for immunizations that are detrimental to children's health. So you would have to get documentation of that from a medical professional who says that that's the case, and that has to be reissued annually. Then there's the religious exemption, which is what we see the most questions about, I think. And it's relatively broad. A parent is required to certify that they hold genuine and sincere religious beliefs which are contrary to the practices required by the public health law, contrary to the vaccine requirements. The head of school has some leeway in deciding this, essentially, and it is up to the head of the organization you can ask for more information, more documentation about why this is a genuinely held belief. It doesn't have to be a particular religion that the belief comes from, but does have to be genuinely held, and so you can and you should get some backup on why that is the case. So you'll have students, most of whom are vaccinated, but some who fall under these exemptions. You need to maintain an up-to-date list of those students, the susceptible students in particular, because in the event of an outbreak, like the measles outbreak, the commissioner, the state or the city commissioner can come in and request that list so that they can exclude, if they choose to, those students who are either unvaccinated or in process in getting vaccinations. And so you'll need to be able to provide those lists. So your action item is to review your policies on vaccinations and admissions requirements, your exemption policies, outbreak lists, etc., and work with the New York City and New York State public health, commissioners of health, to make sure that you have all of that up to date.
Jeff asks whether independent schools need to recognize those exemptions.
Yes.
The answer is yes. And just again, editorial comment, the religious exemption, you don't have to be a particular religion, and the courts have been very unhappy with employers really questioning, whether or not something is a real religious belief. So we basically generally recommend don't go down that path of trying to argue with somebody about whether or not when they state they have a real religious belief, it's a real religious belief. It seems to us to be a losing proposition, although we do have some heads of school who are very tough on this because parents are upset about other kids not being vaccinated. When the outbreaks are taking place, what we have learned, the kids who aren't vaccinated, the health departments basically say you can't come to school. And with the measles, we were getting health departments saying you can't come to school for 3 weeks, whatever the time period, 21 days. Yeah. So we had a college that we represent where somebody was coming down on a train and had measles, and they wanted to close down the college. And we had conversations with them basically saying, what are you doing? We know who's not vaccinated, and so the right results is the people who aren't vaccinated can't come to college. Everybody else can certainly continue to be in school.
We have one more question on the employment side from Julia, whether staff can be should be required to follow the same protocols.
We've been getting this question, and I think we've come down on not requiring them to, requiring them to get exemptions if there's not a law. There are certain professions where it's mandated. Certain healthcare professionals are required to be vaccinated. Some of our the daycare and preschools have that requirement. But where that's not a requirement, I think you may have that challenged. I haven't seen it yet, but we've thus far advised no.
Okay, last two topics quickly, if we have time, George, is one just an overview. Many of you are familiar with this, but a couple of years ago, in 2013, a former student at Hotchkiss sued Hotchkiss and received a $41.75 million jury verdict against the school for injuries occurred while on a school trip in China caused by a tick bite. And I can go into a long story, but in the basis of time, just to say that has changed how we approach school trips, period. And our recommendation is that all schools, for all school trips, be much more careful. And I know, Mark, Lori is on the line. NYSAIS submitted an amicus brief in the appeal of this case. Part of the concern is there are some schools saying we're not doing school trips at all if we have potential for such great liability. What we've been trying to do with our schools is basically all school trips lay out the risks clearly. Basically say this is all trips are dangerous. This trip has the following specific dangers. If it's going to another country, we recommend you go to the State Department and you warrant and represent that you've gone on the State Department website and you've read the risk that they've listed as current risk. There's some trips that we basically say don't go there. The country, like the countries where when Ebola was much more problematic, we were saying don't go to certain countries where Ebola is in a rampage right now. The other piece of sort of the trip issue is we want parents, we have a form that we like parents to sign, basically saying we're aware of the risk and we release the school from liability. On almost all of these trips, except for kids who are very, very young, children are not supervised 100% of the time. And so we like to represent and have parents sign off on that. And then last but not least, and this I think is a very important part, at a lot of schools, faculty put together their own trips. And parents think that it's a school trip and it's not. And the school has some involvement. They may allow the faculty member to meet with parents in a conference room to talk about the trip, but it's not a school trip. It's a faculty member trip. And we want to make those kind of arrangements very clear that school got nothing to do with this trip. And in those, the bar has been raised. I think, faculty and schools, whoever's doing a trip, really need to know what they're doing, especially if there's home stays, where abuse can take place, travel, where it's risky. People really need to have, done real due diligence to ensure safety and also to ensure that if something, God forbid, happens, that they have an action plan in place about how you get, emergency medical and other care to the children who are being taken on the trip. So this is an area which, the bar has been raised. There's a lot more potential liability. The Hotchkiss case has gotten a lot of publicity, right or wrong about, whether or not $41 million is the appropriate, the result of this. It's basically all trips have to be taken very seriously. They have to really, be an analysis of what might happen and what do we do if something happens. And people have to be, on guard to take very immediate and positive responses. So this has really changed the ball game in our view for all school trips. People just have to really not take it as business as usual, but really be much more responsible in planning and in dealing with it.
They're just about to cut us off.
In the interest of time, I just wanted to maybe as a transition mention the importance of insurance, and I don't know if you have a comment about that. I know a lot of schools are reevaluating the insurance that they have to help them more safely bring these trips to reality. And then also just opening up the floor for questions, because we've only got about 5 minutes left, and I know that we would I'd love to hear from the group. So,
great. We agree with insurance.
So does anybody then in the audience have a question they directly, feel free to turn off your mute on your microphone and ask Donna or Mark any question related to any of the topics that have been brought up, or perhaps something that wasn't brought up.
Mark, oh, did I interrupt somebody? Sorry.
No, you didn't interrupt anyone. Yeah, Mitch.
We're ready for you.
Michael, it's you.
In terms of the vaccination policy, does that include after-school programming? We're, as you know, we're connected to a congregation. The congregation has Hebrew school. Would the vaccination requirements follow with that sort of programming as well?
I look to you.
I'm not sure. I would have to look at the definition of school, of admission to school. I'm not sure. My quick thought is no. I think it's school, because we've looked into whether school included our independent schools, and it would be quite burdensome for any sort of program that anybody is organizing to require vaccine requirements in order to get them in. So that's my quick thought, but I would have to look at the actual public health law.
Yeah. If it's a school after school program, I would think the law would apply, right? Because it's for your students, and so it's just a continuation of the school day. If it's an after school program that the temple's putting together, where other kids are invited, I think it's going to be their problem, not a school problem. But we could look. Yeah,
I mean, it talks about no principal, teacher, owner, or person in charge of a school permitting the child to be admitted to attend the school. So I think you may have more leeway there, but as much as I can give you right now.
School specific. Any other questions?
I have one about the volunteer policy, or creating policies around volunteers at schools.
Sure. So actually, I was making a list of sort of hot items that we didn't cover, and one of them would be in that area a couple of different things. One is just sort of misclassification, what I'll call wage hour issues generally. And so there's a bunch of issues in the wage hour area, which could be another NYSAIS program, but that deals with independent contractors, misclassifications. And we're seeing a lot with volunteers and interns, just generally at employers and at educational institutions. I think what you're focusing on is just volunteering at school and your responsibilities vis-a-vis volunteers. We, for many, many years, have recommended that volunteers go through background checks, and that if somebody's coming onto your school premises and dealing with kids, even if they're a volunteer, that there needs to be some level of due diligence that they're not posing a potential risk to the community. And so, yes, we have various agreements that we have put together vis-a-vis volunteers. Can you think of other ones?
Your whistleblower policy will also apply to volunteers. They're specified by the Act. Yeah, it's a little tricky because you want to make sure they are, for the fair labor types of ideas, you want to make sure they're properly classified as volunteers and not as employees. But at the same time, you are going to want some of your school policies to apply to them, so they're not harassed and discriminated against, and those types of policies at the school. So you'll want to go through and see which policies are going to apply and make sense for them versus an employee.
We do see time to time at schools a volunteer come in to teach class, or a volunteer come in to do the help with the play, direct the play, or make costumes, or and that's where some of the wage hour stuff comes into play. Is that really somebody who could work for no money, or do they have to be paid as a part-time or temporary employee? And the law really sort of limits volunteers if they're replacing real employees, somebody that you would otherwise have to hire to do the job. We've had some schools where volunteers actually have administrative titles and are on the on the list. It could be a board member, it could be somebody else, and that's if the Department of Labor comes in and takes a look, that's problematic. That's obviously a bad fact that they're really doing productive work and replacing a real employee, and that's problematic. So volunteers in general require some level of due diligence.
Would this include parent volunteers?
Includes parent volunteers, absolutely.
So we should be background checking all of our parents as well?
We've had schools, where parents are registered sex offenders, and it can be very embarrassing if the parent is the chaperone on
it depends on what they're doing, but
so we like it just because we've had at least 2 instances where parents have been registered sex offenders in the last year, and you don't know because schools don't routinely check for parents as being registered on the sex offender registry. And so the only way you would know is if they volunteered for something and you did some background checking just to be super safe. You don't know. We don't know who our parents are. All we know is they signed an enrollment contract. And so it may sound paranoid, but that's we're lawyers. We're
that's what we do.
we're paranoid.
I think we have time for one more question. Charles, you have been patiently waiting, and then I think you get the last question.
One quick thing on the conflict of interest. At the Maplebrook, we make sure every board member signs a copy of the conflict of interest each year, so it is signed and dated and made part of the permanent records for all board members.
We think that's best practice. Yeah, best practice, no question about it. It's the right thing to do.
Excellent.
That's a relatively new development in the world. That goes back to Enron and sort of in the private sector, which is the Attorney General and the regulators have said not-for-profits to also be having best practices.
Well, we want to thank you, Donna and Mark, so much for your wisdom and for so clearly sharing all of your advice with our participants today.